Officer Dave, would you open the courtroom, please?
The State of Michigan 36th District Court is now in session. The Honorable Judge David S. Robinson Jr. presiding. Good morning.
Good morning. Let's call our first case of the day, which is file number 19180-130. This case is Gravity Imaging versus City of Detroit. Your respective appearances.
Good morning, Your Honor. Ian Coote, 73154 for the plaintiff.
And good morning, Your Honor. Sarah Doman, P79128 on behalf of defendant.
Okay, when we were here last, and that was on March 11th, you guys told me we were close to resolution. Where are we on this file?
Looking at the notes, Your Honor, it looks like we have a resolution. We're just working out the language of the release. And correct me if I'm wrong, Ms. Dolan.
Is that for $5,000?
I had it for 6.
Okay. The last emails I saw were between me and Daniel Grove from your office. I might need to search for your name. Were we corresponding? Because I think Daniel appeared last time.
Yeah, no, the emails that I saw were between you and Dan. So I may not have been, there may have been further emails that I just wasn't
Okay.
All right,
copied.
well, let's do this. You guys are obviously not organized resolution today. Let's give you then a short day. Give you a chance
Perfect.
to talk, let's figure out what's going on. How about, let's see, it's Friday. April 26th. How about April 29 at 11 o'clock? Does that work for both of you?
Yes, Your Honor.
That'll be fine with me, Your Honor.
You know, April 29. Do it at 11 o'clock, okay?
Thank you, Your Honor.
Now,
Thank you, Your Honor.
if you get it done before that, you can fax me out and we'll work it out that way.
Okay.
Oh, actually, we can do it at 10 o'clock like this one. 10 o'clock.
10 o'clock works.
Mr.
That's
Cooper,
fine with me, Your Honor. Yep, that's fine with me, Your Honor.
April 29th at 10 o'clock.
Thank you very much.
All right, thanks.
Thank you, Your Honor.
Okay, Mr. Coote, you're free to go. Ms. Doman, you go to the waiting room
Okay.
because you got one more to go. We will. All right, Mr. Truba. We are on the record calling case number 19181-789, Jefferson Capital System versus Whitney McCombs. By a notice dated March 11th, 2021, after our last pretrial, the matter set for pretrial today, April 15th at 10 o'clock. It's now 10:31. The record should further reflect that this April 15th, 10 o'clock time period was agreed to by both parties on the record. We have an appearance by only one side. Your appearance, sir.
Good morning, Your Honor. Brian Truba appearing on behalf of the plaintiff. My P number is 61752.
Mr. Truba, we don't have a defendant here. What is your pleasure?
Your Honor, plaintiff would move for entry of a default judgment with damages in the amount of $1,442.62, filing fee of $55, motion fee of $20, service fee of $44.48, $75 attorney fee for a total judgment of $1,637.10.
All right, what I'll do is I'll enter the default of the defendant at this time. And you can send your default judgment in under the 7-day rule.
Very good, Your Honor.
Thank you, sir.
Thanks, Your Honor. Have a good morning.
You do the same, sir. We're off the record. We are on the record calling case number 20150-268, Advanced Surgery Center versus City of Detroit. This matter, by a notice dated March 18th, 2021, is scheduled for pretrial today. The record should reflect the matter scheduled for pretrial April 15th at 10 o'clock. It's currently 10:34. The record should further reflect that this date and time were agreed upon by counsel for both sides at our March 18th pretrial. It's now 10:34. I have only one party here. Your appearance, please.
Good morning, Your Honor. Sarah Dolman, P79128 on behalf of defendant, City of Detroit.
Ms. Dolman, have you settled the case?
We have not.
Plaintiff has failed to appear. No good call of that failure having been shown. This matter is dismissed.
Thank you, Your Honor.
Thank you for coming in. We're off the record. Have a good day.
You too. Bye.
Bye-bye. Okay, let's see what we got. All right. Ms. Greco, what do you have?
I believe I have two, Your Honor. Northland Radiology as well as Focus Imaging, both versus City of Detroit.
Okay. Anybody here on either of those two cases?
Yes,
Oh, sorry, go ahead.
yes, Your Honor. I'm here on the Northland Radiology on behalf of plaintiff.
Okay, then let's do that file, and we'll put everybody else back into the waiting room. So that's Zelinski and Greco. Brown, waiting room. Coop, waiting room. Alton, waiting room. Okay. 202. 723. We are on the record. This is file number 20152723. Northland Radiology versus City of Detroit. Your respective appearances.
Good morning, Your Honor. Robert Zielinski appearing on behalf of the plaintiff, P82851.
And Afiola Greco appearing on behalf of the City of Detroit, P83874.
All right, our discovery is closed on this file, folks. Where are we?
We have resolved the matter, Your Honor. You should be receiving our stipulated order here shortly.
Okay, tell me the terms of your resolution.
We have settled the matter at, let me give you the amount here. Do you have it out in front of you?
Yeah, it looks like it's 5,500.
Okay.
All right. All right, parties have advised the court that the matter has been settled. The terms of the settlement have been placed on the record. The matter will therefore be dismissed without prejudice. When your final paperwork comes in, we'll enter that and close it out with prejudice, whatever, you know, how you're doing it. Okay?
Thank you, Your Honor.
Thank you both for coming in. Ms. Greco, you go back to my waiting room.
So Judge, sorry, before I do that, I wanted to let you know that we have Ms. Arbo, who is opposing counsel on Focus Imaging. We have also resolved that matter as well. I'm not sure if she's,
As well.
yes.
Okay, well, let me let Mr. Zielinski go so he can do more productive things. Then we'll do your other case as well. Give me just a
Okay.
second. Uh, 841. Okay, Ms. Greco, this is it Jason Harrison? No. Let me check. Is Jason Harrison on the other side?
No, it's Christina Arbo, but I don't believe she is, she's gonna be here. We ended up going to facilitation and
Okay, then let's do it on the record and call your file. We are on the record calling 20154-841 Focus Imaging LLC versus City of Detroit. This matter is set for pretrial today. The parties had previously set the matter up and had a facilitation on April the 8th. Your appearance.
good morning, Judge. Fiola Greco appearing on behalf of the city, P83874. Following our April 8th facilitation, we were able to come to a resolution and settle the case at $5,000.
And that's subject to city council approval?
Yes.
Okay, then I'll, taking your representation as an officer of the court, we'll put the matter, I'll dismiss the matter without prejudice, and when you're ready for your final closing documents, send them on forward, okay?
Will do. Thank you.
Thank you for coming in.
Bye.
All right, Mr. Coote, you have gravity imaging versus Wayne County,
Correct, Your Honor.
okay? And I'm waiting for Mr. Harrison. Mr. Harrison, you have gravity imaging versus Wayne County?
Correct, Your Honor. Good morning.
Good morning. Okay, let's call your file. We are on the record. This is 20159-628, gravity imaging versus Wayne County. Could I have your respective appearances?
Good morning, Your Honor. Ian Coote, 73154 for the plaintiff.
Good morning, Your Honor. Jason Harrison on behalf of defendant Wayne County, P number 62765.
All right, gentlemen, our discovery closed as of yesterday, I guess, April 14th. Where are we on resolution?
Well, Your Honor.
Sorry, go ahead.
I'm sorry. Go ahead.
Yeah, Your Honor, Mr.
Come on,
Harrison.
somebody tell me.
Mr. Harrison and I, we were talking settlement figures earlier today. I contacted him before the pretrial conference just to discuss the case with him. We're not settled yet, but we're headed that way. I think we've both got depositions scheduled. They were scheduled during the discovery period, but they're set for just later this month. We were hoping to get a bit more time from the court to kind of continue talking settlement and conduct those depositions if need be.
Well, I guess I'm a little confused. I thought we had closed your discovery as of the 14th. And so you guys now want to take depositions or not take depositions? I'm a little confused here. Are you going to take them or not?
Yeah, we are, Your Honor, I am going to take the deposition of the biller. It was noticed up for a week and a half ago. Plaintiff was concerned that it was arbitrarily set. And the other problem in this case, Your Honor, is the doctor that recommended the films to be done is not an employee of Gravity Imaging. So I need to subpoena him, and that's taken some time. So Your Honor, if you give us, I would say 30 days, that's going to get us to a point where we're able to get the depositions done and either proceed to facilitation or settle it right there.
All right, gentlemen, I'll give you the May 13th, but when I say discovery is closed, it's not a wish.
Understood, Your Honor.
Fair enough, Your Honor.
May 13th at 11 o'clock work for both of you?
That'll work for me, Your Honor.
What about you, sir? All right, May 13th at 11 o'clock.
Thank you, Your Honor.
And I'll note again on my order, discovery is closed. So either you will have your depositions or you will not, but I'm done with this.
Thank you.
Fair enough, Your Honor.
All right, gentlemen, have a good day. Thank you for coming in.
Thank you.
We are on the record. This is case number 20153-712. Boz Eagle Transportation for Frederick Speed versus City of Detroit. We have a motion for summary disposition filed on behalf of defendant City of Detroit. Your respective appearances.
Yes, good morning, Your Honor. Alexander Brown on behalf of the plaintiff, Baz Eagle Transportation, P79951.
Good morning, Your Honor. Michael Otten, P81884 on behalf of the City of Detroit.
Mr. Alton, your motion.
Yes, Your Honor. So I know that you've read all our briefs and are fully aware, so I'll make this short and sweet. But essentially, plaintiff's charges for transportation are unreasonable. Plaintiff has the burden of proving that his charges are both reasonable and customary. Just because a fee is customary doesn't make it reasonable. The city is entitled to summary disposition because under the No Fault Act, an insurer is not liable for medical charges that are not reasonable.
Okay, let's stop right there.
Yeah.
I guess I'm confused. Somewhere in the pleadings, did I miss an admission by the plaintiff that the charges that he was seeking were unreasonable?
An admission by
Plaintiff, I'm asking for unreasonable charges. Did I miss that somewhere?
No.
Then how do we get to the fact that because you disagree with them on behalf of your client, they are per se unreasonable?
Well, Your Honor, as stated in the brief, there's no basis for how the charges are calculated at all.
Okay, that may very well be your position. But even the case law that you cite, which talks about how evidence of what third-party payers pay may be, not is relevant, may be relevant.
Correct.
It's conclusive. It's just part of the panoply of information to be provided. And so I'm having trouble with the idea that you're entitled to summary disposition on a disputed amount because you dispute the amount. And that's basically what your argument is.
Well, the court has found that if a charge is found to be on, it's a question for the jury, unless no reasonable jury could find that they're reasonable, Your Honor.
And
And
how can I decide that no reasonable jury could say these charges for transportation are reasonable?
well, Your Honor, when you have, 17-mile trip that's $200 and a 52-mile trip that's $200,
Okay,
how is that reasonable?
it may very well be reasonable. It may very well be unreasonable, but I just don't think it is a subject properly for summary disposition. Well, during the 17-mile trip, were other services that had to be rendered during the trip? During the 52-mile trip? I mean, you just can't say because you charge the same thing for these two things, they are per se unreasonable. And if so, which one is unreasonable? Is the $200 for the 17-mile trip reasonable and not for the 52-mile trip, or the other way around? It just seems to me that what you're trying to do is to claim there's no genuine issue of material fact in what is really a significant part of the subject matter of the lawsuit.
I understand, Your Honor. And that's why alternatively, this is also a motion for partial summary disposition.
Yeah, let's hear your I'm sorry. First of all, Mr. Brown, do you think I should find he's entitled to summary disposition? I assumed you didn't. That's why I didn't ask you.
No, Your Honor.
Okay. Yeah, to me, the real question here is the partial summary disposition for the two checks. Now let's hear argument on that.
Yeah, so Your Honor, essentially the city issued two checks, all for two different checks ranging from service of January 29th to March 6th. If you look at the checks themselves, they state, that they were paid in full accord and satisfaction on the check itself. They state in all caps, paid in full accord and satisfaction on the stub. And then on the stub, it states the dates of service that are paid, and that is the entire dates of service for that time period. Showing that they were paid for every single date of service from the time period. One check is, I'm sorry, Your Honor, let me look at that check quick to make sure I give you the exact date, but it's essentially from January 29th, to February 28th. And then the second check says from period 3-4, which is March 4th to March 6th, showing that those dates of service were paid in full accord and satisfaction. In order to have full accord and satisfaction, you have to have a good faith dispute of a non-liquidated claim, conditional tender of money and satisfaction of the claim, acceptance of the tender while fully informed of the condition. And those factors are all met here with the tender of this check by the city, in good faith of a unliquidated claim, which is proved by this lawsuit here, with our, dates of service listed clearly on the stub itself.
Well, Mr. Brown, one of the affirmative defenses that was claimed here was accord and satisfaction. And is there some reason, and again, I recognize that I'm not talking about a layperson versus a sophisticated business. I'm talking about two sophisticated business enterprises. Given the fact that let me ask this question first. Did you, on the dates of the two checks, the checks being check 17764 for the period 129 through 228, render any services during that time window other than transportation?
No, Your Honor. It was strictly transportation services.
For the period check 17805, period 341936, did you render any services other than transportation?
No, Your Honor. It was strictly transportation.
Because in both of those checks, not only do you have the in full satisfaction language on the face of the check, you have the dates of service and, more importantly, the service, transportation. So I'm having trouble with the idea that being on notice from their answer to your complaint that they claimed that there had been accord and satisfaction, at least partial, having accepted checks as a sophisticated business that said for full accord and satisfaction for transportation, the only services rendered during these specific dates. Why would they not be entitled to summary disposition, partial summary disposition, but as to the transportation services covered by those two checks?
Yes, Judge. So in brief response, we are not disputing the language that was on the check and the stub. That's clear. However, we do dispute that the law cited by the defendant to the UCC here is not applicable to the No Fault Act. As we all know, the No Fault Act governs no fault disputes. The Michigan legislature had the ability to codify, to include language of the UCC when they enacted the No Fault Act. They did not do so. I believe that the advocacy organization for patients and providers versus Auto Club case is directly on point here. And it states that if the amount paid is less than what the provider charges, it does not violate the act where the amount paid is based on a proper determination of what is reasonable, and the insurer will agree to defend and indemnify the insured if the healthcare provider sues for the balance. So when these payments were issued, none of that was done here. There was no explanation as to how this quote unquote proper determination of what is reasonable was made. All that we have are two checks that total $868.84 being paid on a combined $3,400 worth of services that were billed, and we have a stub. That's it. There's no explanation as to how these rates have been established. There's no explanation of how these charges were reviewed, what the basis was for determining these rates. And there was also not a statement that they would agree to indemnify and defend the patient if they were sued for the balance. The advocacy case is on point, and it says that when rates are in dispute and they issue partial payment, those two elements have to be there. They have to accompany the check. Second of all, the advocacy case also states that the medical providers have the ability to challenge the rates. It specifically states that medical providers can challenge an insured's failure to fully reimburse them for medical bills as a violation of the No Fault Act. However, we do have the burden to prove that those rates were reasonable.
Well, I guess my question is, I understand and I agree with the concept that medical provider can say, no, my service was worth $3,200, not $800. My problem comes in that you cash the check.
Of course.
If you had said, I'm sending back your check because it's not for the full amount, that's one thing. But the check was offered to you in a particular context. That is for full court. Let me see. What's the language exactly? Paid in full accord and satisfaction for services referenced on stub. And so how then do you, if you say the UCC does not apply, then ordinary contract law would apply. And you've taken a payment under a restricted agreement. That is, if you take my money, you've agreed that this is done. And you say, that's my problem. Had the funds been rejected, and again, I'm talking about a situation where I have sophisticated business entities on both sides. I'm not talking about business entity versus mom and pop kettle. That's not what was before us today. We're big boys here. This is the big boy league. And I have two sophisticated businesses. One saying, I'm prepared to pay you this amount of money in full and complete satisfaction of the bill services for these dates. Then I have another sophisticated business saying, I'll take the dollars, I'll take the money, and now I'm going to challenge the balance. I have a problem with that.
So I understand your concern there, Judge. However, we argue that there's one additional requirement that must be made for this to be valid. It has to comply. It has to be, that payment cannot violate the No Fault Act, which is exactly what the advocacy case says. And it says it does not violate the act where the amount paid is based on a proper determination of what is reasonable, and the insurer will defend and indemnify the insured if the healthcare provider sues the insured for the balance. So what the city has not done in this case is it has not shown that it's made a proper determination as to what is reasonable, and it has not also said that it will defend and indemnify the underlying individual here, who is Frederick Speed, in case my client determined that we were going to sue Mr. Speed. So not only
has your client sued Mr. Speed?
We have not sued Mr. Speed, Your Honor. Instead, we have sued the city for the balance. So
Okay.
not only would we argue that, okay, maybe there was an accord and satisfaction there in regard to cashing the check, but that also cannot violate the No Fault Act. And that's what we're arguing as the defense to this motion, is that the payment was in violation of the No Fault.
Mr. Alton.
Yeah, Your Honor, I don't see how an affirmative defense that's given to the city or any other business entity of accord and satisfaction of payments made in accord and satisfaction, their client could have rejected the payment right there. They could have said, nope, this isn't our rate, we're not taking this. But instead, time and time again, we see take the money and then sue us afterwards and try to collect the balance. They knew full well that they were accepting a check in full accord and satisfaction. They understand the tenets. I disagree about it, violating the No Fault Act. And the city complied with everything it's supposed to do in this situation. And we're entitled to summary disposition on these particular services.
Yeah, I think that the problem that as I indicated, that I have here is that on the one hand, Mr. Brown, you argue that the UCC does not apply. But then if that's the case, then we have ordinary contract law to look at. Mr. Alton's argument is we did the things that the UCC requires in order for us to have an accord and satisfaction. So we got one or two things here. If we take Mr. Alton's position, then there's clearly a valid accord and satisfaction. If we take your position, we're back at the same point. And the whole idea of the No Fault Act is to provide prompt payment. And it cannot be a conclusion of the No Fault Act that if you are in a situation where the object of the exercise is to get prompt payment, not only for wages, but also for services, that if they tender you a check to you and say, we're paying $800 of the $3,200 or $3,400 that you billed, you can say, I'm going to take the money, and at the same time, I'm going to bring lawsuit. It seems to me the advocacy case is distinguishable here, and I'm going to grant partial summary disposition only as to those dates of services between 1/29/19 and 2/28/19, which were covered by check 17764, and as to any services for transportation for the period 3/4/19 to 3/6/19. So you can, Mr. Alton, you can craft the order. It will be an order granting partial summary disposition, denying your motion in general for summary disposition on the grounds that we discussed earlier. I just don't believe that the fact that you disagree with the child makes it per se unreasonable. And that's really what your argument boils down to.
I got to do what I can, Judge.
Sometimes a rapier is better than a broadsword. I'll look forward to your order. Send it out under the 7-day rule. And are those the only items of dispute here?
I believe so, Your Honor.
Yes, Your
Brown?
Honor.
Okay, then send out under the 7-day rule. So your order should include the findings as well as the dismissal of the case on the grounds of summary disposition, dismissing the claim with prejudice.
As to those specific services, and then we have.
Yeah, Mr. Brown said you had no other issues in this case.
Oh, well, no, yeah, so there are still outstanding charges above and beyond that in March.
Okay, no problem then. Let's do this. Let's give you a return date of May 13th. Does that work for everybody?
Yes,
Should.
Your Honor.
Yes, Your Honor.
Mr. Brown?
That works for me, Judge.
Okay, May 13th at 11 o'clock will be our next pretrial. In the meantime, you will submit your order in relationship to partial summary disposition in relationship to the covered services covered by check 17764, 17805.
Okay.
Okay, gentlemen, May 13th at 11 o'clock. Let's get this done so we can narrow our dispute and figure out what it is we're actually arguing about.
Thank you, Your Honor.
Your Honor.
Thank you, sir. Thank you both for coming in.
Seeing you, Alex.
Have a great one. Yeah, Mike, I'll talk to you soon.
All right, sounds good.
That concludes the